Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Today I want to talk about two things. The first is the causation instruction and why I think it's the most important instruction in this entire package. And two, the two questions that came from the jury and what those might mean. Now, I also saw a thumbnail, I didn't actually look at the video, from a legal channel who said, would I vote to convict? Well, that's not my job, right? The only people who have a vote in that are the people who are on the jury, and it isn't proper, I think, for people to offer opinions, for lawyers especially, to offer opinions about guilt or innocence in a direct manner like that, because even though the judge tells people don't look at the media, don't read the newspaper, don't watch the evening news, don't look at YouTube, all of that, even though the judge says that, my bet is that at least 15%, maybe 20% of jurors ignore that completely. And the reason they do is because jurors want to know what's been excluded. They want to know what has been removed from their consideration. And those who do it and who are smart enough not to mention that they've done it oftentimes take a lead role in arguing for either conviction or acquittal based on the information that they have obtained from outside sources. And yes, the jury system is not supposed to work that way, but when the jury system was first implemented in the 1700s, there was no TV, there was no radio. In many cases, there was no newspaper. The only thing you had was the jungle telegraph inside the community where the trial was taking place. And as a result, the jurors were not as susceptible to that sort of community influence. And then I mentioned the other day the case of Sam Shepard, where F. Lee Bailey won an acquittal at the Supreme Court, basically because the media attention made it completely impossible for that man to get a fair trial. So the adjustments that have been made in jury instructions over the years have been designed to eliminate that bias that comes from the media, but that doesn't always work. And I think we need to understand that, even if we don't know really how to fix that yet. There's nothing we can do to determine whether or not a juror actually honors their oath. It's my hope that they would, but because I am afraid that somebody will watch me on YouTube and say, that guy says, I don't make conclusions on ultimate guilt or innocence, if at all possible. So, and at least until after the trial is over, and then I say, it's exactly what I thought would happen. What else am I going to say, right? We all want to look smart. But the fact of the matter is, sometimes I have been completely flummoxed by the results of juries. Casey Anthony's trial is a good analogy there. I thought at the time that they had proved she was a liar, but they didn't prove she was a murderer. And indeed, that's exactly what the jury decided. But I honestly believe they were probably going to convict her because that girl looked guilty as sin. Apparently, the jury felt like the state had not proved their case. And that's really at the crux of the first issue I want to talk about, which is this causation instruction. Now, here's the causation instruction, and this is from the Section 16 of the criminal instructions in Michigan. And it says, act of defendant must be cause of death. Now, all this stuff below where it says use note, the jury doesn't see any of that. Now, the court can preface this by saying there may be more than one cause of death. In this case, that is certainly what the state is arguing here. They're arguing that it's not enough to convict Ethan Crumbley of shooting the place up. You have to convict the defendant of providing the means to do that. So here's what the instruction says. It's not enough that the defendant's act made it possible for the death to occur. And indeed, that's pretty much what the evidence has been aimed at. It's possible. In order to find that the death of one of the victims was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural and necessary result of the defendant's act. Well, they didn't lock up the gun. And maybe that could result in it, but is it as somebody pointed out the other day in the comments, there are parents who leave guns unlocked all the time, particularly here in the South, and nothing bad ever happens. So it's not the natural or necessary result of the defendant's act. So I think this particular instruction is going to be one of the most important, and I think it's one of the reasons why the jury deliberations have gone on as long as they have. Now, yesterday there were a ton of really interesting comments in the live stream that was on YouTube. Now, I just picked this one at random, but on this one we have guilty Air Force. And yeah, I know that's not Air Force, but this is a family channel. This is why 98% of the people involved in the court system take a plea deal, can't count on a jury. And then somebody says Jennifer is innocent. And then somebody says, made me sick when the closing argument defense made was how dare you hold parents responsible for their children. And then Richard, better than that guy, guilty, guilty Air Force, not guilty, not guilty. These are some of the milder comments. One person on there yesterday, and I was amazed at this one, said basically, I don't understand why it's taking so long. They should have brought back guilty verdict long ago. What's taking so long? And normally I don't comment on these live streams because nobody pays any real attention to it anyway. But I said, it could very well be that the jury is actually honoring their oath and they're taking a time and they're deliberating and they're looking through all this evidence and they're deciding what part of this evidence applies and what part doesn't. And did the prosecution really cherry pick? And all of these other things that were raised by the defense. And of course, all of the evidence that's raised by the prosecution. And I said, the jury has a duty to deliver justice. They don't have a duty to deliver a guilty verdict unless the person's really guilty. And I think sometimes there are people who just get lost in the weeds when they watch these trials. But later on in the day, the jury came back with a series of instructions. Let's look at this first one.
We got a question from the jury. I thought was really easy to answer. I guess I don't know if there's an agreement about that, but if you don't agree, then we're going to decide on the record how to answer it. The question is whether the standard jury instruction 16.10 and 16.13 are different. But it says the 16.10 and 16.13 two different ways that we can conclude the involuntary manslaughter, or a 16.13 a support to 16.10. So I guess I would say the answer to the first question, isn't it? Yes.
It is, Judge, and I would just ask that the court reread 20.30A, which clearly articulates that. So I think that's why it wasn't just a yes or no response. I think this instruction, 20.30A, is right on point to the question.
Okay, so can I answer the first question, yes?
Yes, Judge.
And then say, please refer to 20.30A unanimity.
Yes, Judge.
Your Honor, I'm not sure. I'm trying to find 20.30A. Okay, I believe the court is correct. However, the way I read the question is that the jury is confused, obviously, about there being two ways to prove the charge. When they ask about one instruction supporting another, I believe that they should reread 20.30A, and then the one theory of the prosecution is 16.13, which describes the legal duty. I believe the second theory by the prosecution is 16.10, which describes the theory. Okay, but I think what supports 16.10 is the definition in 16.18. So when this jury is asking for a question about support, I believe the confusion lies in the fact that
they didn't ask me that.
Well, I when they say, I don't see how 20.3A clears up the question they're asking.
Well, to me, I think the judge probably got this one right, although you'll notice that Shannon is making some objections here to the jury instructions. She's not pushing too aggressively against the judge here, but she's making her objections for the record, because if Jennifer Crumbly gets convicted, then she has a motion for new trial she's going to file, and she's going to raise these objections. One of the things you have to be careful about is giving a jury a roving commission, where you can pick one from column A and two from column B and one from column C and mash them all together and then decide on a completely different instruction that somebody is guilty. And essentially that's what Shannon was arguing on that particular issue. Now let's look at the next issue the jury raised.
I got a question from the jury that I gave to both attorneys. Answer. The question is, can we infer anything from evidence for witnesses that the prosecution did not bring, specifically not bring in the shooter or other people who could answer how he specifically got the gun? The answer is no, right?
Correct, Jeff.
Do I need to refer them to, do I need to send them 2.9 or 3.5?
I believe you just send in 3.2, Your Honor, because a reasonable doubt is defined as a fair, honest doubt growing out of the evidence or lack of evidence, and it appears they're asking about lack of evidence.
It looks to me like the judge probably made an error here. And I don't know if it will result in reversal or not, but she should have given the instruction that Shannon Smith requested. And let me show you why that is. This is the reasonable doubt instruction, 2.5, that Shannon Smith was talking about. We can ignore, for purposes of this jury instruction and that question, everything except number 3. Number 3 says, a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. So the defense does not have a burden. They don't have a burden of proof. They don't have to put up any evidence. They don't have to bring in the shooter and make him tell why he did what he did. They can't bring in the shooter and make him say, you know, Mom didn't have anything to do with this, because he still has an appeal pending, and his attorneys are going to tell him to keep his mouth shut. Now, does he have any real chance of getting a reversal on his trial? I doubt very seriously that he does, but no attorney is going to risk a malpractice claim by letting him testify. But this is what's important. It's the lack of evidence, and they're asking specifically about a lack of evidence. Now, one of the things that I frequently say is that in every criminal case, the prosecution enjoys a sizable home field advantage. Prosecutors get a lot more leeway for 2 reasons. 1, they are perceived to be doing the right thing, and 2, they have the burden of proof. So if there is a close call, the close call is most likely to go to the prosecution, and I think that's what happened here. But the failure to reinforce that reasonable doubt instruction, as was requested, could very well cause any guilty verdict obtained to be reversed. And I think that's an important consideration. And if I were the judge, the first thing I would do this morning is fix that problem that I created. I don't know that she'll do that, but that's what I would do. So that's what I have for you today. I appreciate your being here and listening, and I especially appreciate all the comments. They have been terrific, and I have been happy to see all of the new people who have come on. Thank you so much for joining. And again, all of your comments make this channel better. Please feel free to disagree with me about anything. I do ask that you try to keep it clean. And I would point out that my parents were married. So at any rate, thank you very much. And if you have a chance today, do something nice for somebody. I made gumbo, real Louisiana gumbo, for my wife for dinner last night. And then I sent it with her to work today because our daughter likes gumbo and they will eat that for lunch today too. So in our house, we believe cook once, eat twice, and that's sort of what we do. We always have leftovers. But Again, I do things to make people happy because it makes me happy to do that. If it makes you happy to do that, strike out today and do something nice for somebody. Because kindness, that heals wounds that even the naked eye can't see. So thank you so much. Catch me down here at the beach tomorrow. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.